no one is ever going to come into this courtroom
Welcome to my channel, The Law Log.
and be intimidated in some way by some threat to their profession. Okay. Court does call the case of the people of the state of Michigan versus James Witt.
On behalf of the people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Ben. I'm here working on behalf of Mr. Whitley, James Whitley.
Thank you. All right.
Counsel and I have.
Yes, you may.
Thank you.
The 14th District Court of the County of State of Michigan is now back in session. The
You may be seated. Back on the record in case of people of the state of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Ben. I'm here with on behalf of Mr. Whitley, sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
This is a critical shift. The defense starts walking back the accusation. But notice how careful the wording becomes in law. Even a slight suggestion can carry serious consequences, so ask yourself, was this really concern, or was it a calculated move that just didn't land the way it was intended?
My concern.
I'm not asking for your concern. I'm asking for, you have made an accusation that, know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam, that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
There were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story. I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me.
Now the judge zeroes in, demanding a clear explanation. This is where legal arguments are stress-tested in real time if your reasoning has cracks. This is the moment they show, and right now, the defense is struggling to keep that argument standing under pressure.
What happened now that you know that they're there? How that changed the whole mindset?
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed at trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense side. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent.
This is the turning point the judge draws a firm Lenino one in this courtroom will be pushed or threatened for doing their job. That's a powerful reminder. The legal system only works when both sides can operate without fear, and anything that disrupts that crosses into dangerous territory.
You from proceeding to defend your client or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you
I did not.
if you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward to this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her?
This case doesn't just...
And just like that, the entire focus shifts. This case is no longer just about the defendant, it's about the conduct of the defense attorney. One statement has flipped the courtroom dynamic, proving how fast things can spiral when professional boundaries are tested.
walk into controversy, it detonates into a full-blown courtroom confrontation where the real issue isn't the crime, but the conduct of the defense itself, and how one reckless statement nearly puts a lawyer's entire career at risk. In People versus James Whitley, what should have been a standard preliminary examination turns into a tense showdown after the court is informed that defense attorney Mr. Bennett allegedly threatened to file a grievance against the prosecutor if she proceeded with the case. That single move instantly shifts the spotlight from the defendant to the defense counsel, and the judge wastes no time addressing it head-on. The court makes it brutally clear, no one, absolutely no one, is going to intimidate another party in this courtroom, especially not by weaponizing professional complaints. The judge treats the allegation seriously, questioning Bennett directly and demanding a clear explanation on record. At first, Bennett tries to soften it, claiming it wasn't a threat but rather a concern about ethical obligations that The prosecutor might be failing to properly investigate facts or could be pursuing a case against someone potentially innocent. But that explanation doesn't land. The judge presses harder, exposing the flaw in Bennett's logic, because even if the defense disagrees with the prosecution's approach, that doesn't make it grievable. Courts exist to test evidence, challenge credibility, and resolve disputes, not to shut down proceedings through intimidation. And that's exactly what the judge believes Bennett attempted to do. As the exchange unfolds, it becomes painfully obvious that Bennett's words crossed a line. What he may have framed as caution was received and reasonably interpreted as a direct threat to the prosecutor's career. And in a courtroom, perception matters just as much as intent. The judge calls the behavior inexcusable and even sanctionable, emphasizing that suggesting disciplinary action simply because the prosecution is doing its job is not just improper, it undermines the entire justice system. The tension escalates as the judge warns Bennett that he himself may now be subject to being reported, flipping the entire situation upside down. The man who tried to question the prosecutor's ethics is now being questioned for his own. Realizing the gravity of the situation, Bennett shifts tone completely. He admits he didn't phrase things properly, acknowledges that his message was inappropriate, and ultimately agrees to self-report his conduct under professional responsibility rules. But even that doesn't fully calm the storm. The judge makes it clear that self-reporting doesn't automatically resolve the issue. The court will still decide whether further action is necessary. That's how serious this moment is. In all, the judge's years on the bench, this kind of conduct stands out as unacceptable. The courtroom dynamic becomes less about the case itself and more about maintaining the integrity of the legal process. Meanwhile, the actual case against Whitley takes a back seat. To avoid further complications and unnecessary delays, both sides agree to streamline part of the process. The defense stipulates key facts confirming the defendant's identity and relationship to the alleged victim, so a witness doesn't need to be called back just for basic identification. It's a practical move, but it doesn't erase what just happened. The court ultimately adjourns the preliminary examination to a later date, giving time for the dust to settle and for any potential disciplinary decisions to be considered, but the message from the bench echoes far louder than the procedural outcome. The courtroom is not a place for intimidation, games, or veiled threats. It's a place for law, evidence, and accountability. And in this moment, the judge draws a hard line protecting.
Final takeaway: this wasn't just a hearing. It was a lesson in accountability in the courtroom. Every word matters. One misstep can put your entire career on the line. So what do you think? Was it a misunderstanding? Or did the line truly get crossed here?
Not just the prosecutor, but the entire system from being manipulated. In the end, this case becomes a powerful reminder that lawyers aren't just advocates, they're officers of the court. And when they step out of line, the consequences can come faster and harder than any ruling in the case itself. One sentence, one misjudged tactic, and suddenly the focus shifts from defending a client to defending your own license. That's the real drama here, not the charges, but the near collapse of professional boundaries inside the courtroom. If you want more intense courtroom moments where lawyers themselves end up on the hot seat, then don't just scroll past smash that like button, hit subscribe right now, and stay locked in, because the next case might not just test the law, it might test the people enforcing it.